Bhoe, thank you for watching, thank you for listening. And we now go on to our guest, Mr. Kelvin Ramkissoon. Good morning, Kelvin.
Good morning, Dr. Tiwari. How are you?
How are you doing?
Great to see you.
I got you up bright and early. I hope it's not too early for you.
No, I'm accustomed to these hours.
All right, very good. Well, today we're going to talk a little bit about procurement. And I'm glad that you are on. I know that you have a certain expertise in this area. You've studied the area beyond the ordinary law. And I want to address some of these issues. And I want you to do most of the talking and positioning on some of the issues before us now. Now, in Trinidad and Tobago, we've had the Central Tenders Board Act. And that act existed for a long time, and it was felt to be inadequate. Many white papers were brought to the parliament of the country, but no decision was ever taken to replace it with legislation. And during my time with the People's Partnership in government under the Prime Minister then, Kamla Persad Bissessa, we drove the issue of procurement as a serious issue. And I piloted a bill which became procurement law in January 2015. That bill was completed and fully debated in 2014. Following that, when this administration came in, that is to say the Keith Rowley administration, the Minister of Finance, who led the charge on procurement for the current administration, made amendments on 3 occasions to the procurement bill of 2015, January, and has now presented to the Parliament for debate the regulations for the bill. All right, so we had the Tenders Board Act, we had the Procurement Bill of 2014, we had amendments to the bill from 2016 on, and now we have the regulations. It has taken us a long time, but we've gotten here. You want to, based on that kind of framework that I've outlined, you want to talk a little bit about the business of procurement, the procurement law, the regulations, and where we are at the moment?
Yeah, thank you very much, Dr. Tiwari, for having me on. It is correct that the procurement law, the Public Procurement and Disposal of Public Property Act, number 1 of 2015, was passed. And the thing is that that act has not yet been fully proclaimed. Only certain sections of that act have been proclaimed to create the Office of Procurement Regulator and other bits and pieces along the legislation. The act will seek to repeal the Central Tenders Board Act. As you have said, it's an archaic piece of legislation, 1961. And throughout the last 4 years or so, there have been amendments. And one of the major amendments, or 2 of the major amendments, first one was to create a review board as a step towards challenge proceedings brought by suppliers and contractors. So if you are aggrieved by the decision of a procuring entity, let's say you don't get a contract or you think something may have gone wrong, you can bring proceedings and challenge it. That's for the first time in our law of Trinidad and Tobago that we have had such a provision. The second major amendment, as you know, took place with much controversy and much talk, much hullabaloo around Trinidad and Tobago, was to Section 7. And Section 7 of the Act, as was passed in its first emanation in 2015, was amended to remove from the oversight of the procurement regulatory body, the OPR, Office of Procurement Regulation, G2G, government-to-government contracts, so that if the government of a foreign state is contracting with the government of Trinidad and Tobago, the OPR will no longer have oversight over that. If you ask me, Dr. Tiwari, I think that we must realize that there was a similar parallel in the 1961 Central Tenders Board Act, as amended several times over the years, right up to 1993 and early 2000s, in which if the government of Trinidad and Tobago had contracted with a foreign state or government, then it removed from the oversight the Central Tenders Board process or procedure, so that the government could contract directly with that foreign state. Hence, you have people like Shanghai Construction, China Railway, and so on, coming in into the 2000s, building the Hyatt, building the waterfront, and so on. So that the Section 7 really is a parallel provision which mirrors that, save and except that it removes from the oversight of the Office of Procurement Regulator. Regulator will have no role over that. I believe that that could have been done in a more principled way, and I can offer some suggestions if you wish.
Yeah, I'd like to hear your point of view. My own view is that, well, I mean, I was in Parliament at the time that these amendments were brought, and I opposed personally, and at the time, the review board in its entirety, because I felt it created another layer of bureaucracy when the procurement regulator and the board should have had the power to determine things, and if a person felt aggrieved, they could take the matter to court, because that provision was always available to them. But by creating another layer now, appointed in the same manner, basically you take away the authority and the power of the procurement regulator, and you create an arbitration system, a review system. To me, that is an unnecessary layer. The second issue that you raised, which is the Section 7 issue, this matter was fully aired before the legislation was brought to Parliament, and we got a number of positions on it, and there was a consensus by private sector, government, independent senators, IDB, European Union, the private sector in Trinidad and Tobago, basically that we needed to have government-to-government contracts put under the scrutiny of the procurement regulator. And therefore, when I was not in Parliament when this particular matter came, but I would have opposed it very soundly. And I think the opposition at that time took a hard line in opposing it as well. So I would like to hear from you, because you are saying that, all right, you might want to move Section 7, but you need to do certain things to make up for the fact that you were removing government-to-government arrangements from public scrutiny through the procurement regulator.
Yeah, well, the first thing we must realize is that Section 7 in its amended form effectively creates the opportunity for procurement to take place in a cabinet room with absolutely no oversight, no public scrutiny. And that flies in the face of the objects of the Act under Section 5, which are transparency, accountability, value for money, all these factors, all the range of factors which are contained in Section 5 and which accord with modern governance, good governance principle. But I think that even if there may be sound policy reasons for any government wanting to remove the oversight of the OPR and wanting to contract directly with government-to-government abroad under technical treaties and technical agreements and cultural corporations and so on, which we sign liberally in this country, it could very well be that the very contract could have been lodged with the OPR for public scrutiny, right? And perhaps the areas relating to trade secrets and commercial secrets and so on could have been redacted, so the public, if the foreign government or the government of Trinidad and Tobago is concerned that those trade secrets or commercial arrangements should not be made public, those things could have been redacted, and the OPR could have oversight of areas such as variations, contract overruns, and all of these things could be put into the public domain, so we would see that we are getting value for money and so on. And I think the most glaring thing here is that I understand the necessity to remove commercial and technical information, which may be trade secrets and so on, unique to particular companies. But I certainly don't think it is open to the government or any party to remove pricing, because this is taxpayers' money, and you have a duty of transparency and accountability. So it could have been done in a more principled way.
Okay, I just want to make a point about public scrutiny. The way that bill was designed, the 2015 bill, was that you would have a decentralized procurement system. So every state enterprise, every ministry, etc., every government entity will be able to do their own procurement. So that created a lot of freedom, a lot of flexibility, etc. But every single procurement that took place in the public, on the public's behalf, on the citizens' behalf, through the government or state entity, would have to be filed with the procurement regulator and the board and that office. Yes. And therefore, it made the public regulator the custodian of the scrutiny process. But more than that, it then required the public regulator within a specified period, I think it was 90 days or 120, I can't remember now, to bring this matter to the parliament. And then it would be subject to the scrutiny of the Public Accounts Committee. The Public Accounts Committee is made up of government and opposition members and chaired by an opposition member. And therefore, every single transaction that was filed with public procurement regulator would have to come to the parliament for public scrutiny. And as you know, the Public Accounts Committee is a public discussion by a parliamentary team. Now, what this section, the removal of Section 7 now means, and you are correct, it does fly in the face of Section 5, which has all these grand ideas about what procurement should do. What this does is that it takes away the public procurement process involving government-to-government relations, not just from the scrutiny of the procurement regulator, but the scrutiny of Parliament itself. And I find that very, very disturbing, because it means two governments can make an arrangement. So, for instance, we do not know now what arrangements were made with the Australian government for the ships. We do not know what arrangements were made for the two boats that now sail between Tobago and Trinidad and Tobago. And, you know, those kinds of things, I mean, I can't understand why a government would not want to lay that bare so that the public understands how it conducted its business with taxpayers' money. Would you comment on that a little bit?
Well, I think in the case of the Australian vessels and the APT James vessel and the other one, remember this act is not yet fully proclaimed, and the cabinet took it upon itself through its various emanations of ministers to purchase those vessels and so on. So it contracted directly. So we have to understand, with the absence of full proclamation of the PPDP, Public Procurement Act, then, that there was no application of it. So Section 7 wasn't even created as yet, or the amendment to Section 7 wasn't even created as yet when the government entered into those arrangements. So it took it upon its own to do these things and procure directly with a foreign government, perhaps using its powers under the now existing Central Tenders Board Act, which is still law until the full proclamation of the PPDPA.
That is correct. No, I concur. I agree with you on that, which is that but I would think that one of the things that the government would want to do is to take these various contracts, which are not subject to the scrutiny of the procurement law of 2015, because it's not proclaimed. I would think that they would want to send it to the procurement regulator. But if in the new law with the amendments you don't have Section 7, then there is no such obligation. But I would think a government would want its population to know that it did a transaction that was well above board and fearless to public scrutiny. The problem with the law that we have now is other things like that could happen once the law is proclaimed, and government-to-government arrangements could proceed apace. And we've had, without public scrutiny, and we've had a situation here now where more and more things are coming to the country which says that, you know, there are obligations for non-disclosure. And, you know, what is the point then of procurement regulation? What is the
not
point?
only that, it's like, sorry, I beg your pardon.
What is the point then of procurement law? Yeah.
It also flies in the face of freedom of information and the very good pieces of legislation that we have. You would recall some months ago there was an attempt to remove a particular application on a particular set of circumstances from the FY. The public clamored against it and succeeded in having the government retract. So yes, it does fly in the face. It does fly in the face of transparency. It flies in the face of accountability. And it flies in the face, in my respectful view, of good governance. That is what it does.
All right, let's get to the regulations now. The regulations have not yet been debated. They have been put out. And of course, whenever you put out something in Parliament, the public can comment on it. So consider this a free opportunity, that's to say a free in the sense of a freedom opportunity to comment on the bill so that the public can understand. What do these regulations say, and what is reasonable and what is objectionable?
Well, the regulations have been in the making for a long time, and there were various emanations of it, as far as I understand, over the last few years. These regulations are absolutely necessary for the Act to work, to give it teeth, for workability of the Act, to coin a phrase. And the regulations have been laid in Parliament. 10 sets of regulations have been laid, and they are subject to affirmative resolution of the Parliament. That will come up sometime for debate, I imagine, in September in the new parliamentary term. So these regulations deal, for instance, with the methods of procurement. They deal with the challenge proceedings, and they deal with various other facets of the Act to get it to work. There are bits and pieces of the legislation, of the regulations, for instance, that I think sort of compromise the object. Every time we do a procurement, we harken back to the Section 5 objectives, see whether they comply with accountability, transparency, value for money, and that sort of thing. Bits and pieces of the regulations, however, do confer a lot of discretion on the public officers doing the procurement. And I think that may be subject to abuse. Now, don't get me wrong, it is extremely important that we exercise discretion in public procurement, in the procurement training that I do. And in my classes at LOCTAC and so on, I encourage my students, who are very often CEOs and senior procurement officers at the statutory bodies and state corporations, to exercise their discretion. But to exercise your discretion, you must know what you are about. You can only exercise that discretion within the limits of possibilities under the Act. And take, for instance, the method of procurement that you choose, whether you choose to go by open tendering, by selective tendering, by sole select, and so on. It gives them a discretion. There is no real, what do I say? There are certain attempts in the regulations to tell you when and in what circumstances you can employ a particular method of procurement. And it follows to some extent what is called the UNTITLed model, which is a 2011 model piece of law. But I think just to draw one reference, dealing earlier, and I heard the opening of your program where you dealt with the floods and the rains and so on, that will attract most definitely, Dr. Tiwari, a sole select method, right? A sole select method. You choose a contractor to go and fix the roads, to clear the debris, to clear the drains and so on, as a responsive reactionary measure every time rain falls. Now, one of the things is that we must realize that procurement planning is big under this legislation. And there is the necessity under Section 27 to file an annual procurement plan. Because rainfall, natural disasters, and so on are anticipated events. So that we need to get away from this overemphasis on sole select method, because that flies against fairness, which is one of the objectives, equity and fairness under Section 5. So we need to plan properly, or more properly, for procurement in these anticipated events. And I think that certain parts of the regulations will tend to give too much discretion to the procurement officers.
Okay, so you think, all right, so, all right, I read you. You are saying that basically this discretion creates the conditions and the opportunities for things to go contrary to the intentions of the act. And I want to deal frontally with this issue. I mean, when I piloted this legislation, the whole purpose of the legislation was to deal with corruption and to use procurement as a developmental tool for Trinidad and Tobago, so that procurement became part of the development process, but it also addressed the issue of corruption. And in fact, when the procurement bill was passed, although it wasn't proclaimed, we rose in the corruption index. Right now, we have fallen again in the corruption index, perhaps because we have delayed too long with the procurement legislation, perhaps because of the amendments. And there may be other reasons as well. But the whole purpose of procurement is that you want to protect your taxpayer, your citizens, and you want to create the conditions in which government and public officers are insulated from corruption. Do you think that we have succeeded given the amendments and the regulations that we are doing now?
Well, Dr. Tiwari, it might surprise your viewers to know that research has shown that there is no positive correlation between more anti-corruption legislation and less corruption. And I can name country examples: Pakistan, India, Nigeria, which has a plethora of legislation to deal with corruption in procurement and the mining and extractive industries. As I said, India, Pakistan, and so on. When you compare those countries with places like Norway and Sweden and New Zealand, which score very, very well, almost first, second, and third consecutively in Transparency International's Corruption Perception Index, those countries have very, very little pieces of legislation to deal with corruption. And you compare that with the other countries which have a plethora of legislation, 27, 28 pieces of legislation, they continue to score poorly. And the literature shows as well that notwithstanding that you may have proper procurement legislation, it is a very good attempt, an excellent attempt, but it doesn't necessarily mean that it would abate corruption. You have to have the right variables present, for instance, like the political will to deal with it. The OPR is a regulator. It must be properly funded, properly staffed, and be serious enough to deal It is a regulator which deals entirely with government entities, the public bodies, the statutory bodies, the ministries, and the state corporations. Those are the three major bodies. Are we serious about regulators in this country? We have had the examples of the Clico debacle, the HU Hindu Credit Union debacle, under the watch of Central Bank, which is a regulator, under the watch of the Commissioner of Cooperatives, which is a regulator. All of these things took place. We've had the example of Greenville, where people were flooded almost to their roofs and drowned, and nearly drowned. Town and country planning is a regulator. So we have to be serious. We have to have the political will to deal with it, and all the right variables, including capacity training of people, of those who engage in the procurement function, is paramount, because they are subject. It is somewhat unfair to people if they do not have the requisite training and capacity to deal with this procurement legislation. It's an extremely complex piece of legislation, all-encompassing. It is unfair to them to be subject to multi-million-dollar, $500,000, $2 million fines, etc., when you do not have the relevant capacity and training. So I call today complementary, as a gesture complementary to the working of this act, for public officers and those who engage in the procurement function to be properly trained to deal with this law.
All right. So you think some kind of training and preparation, that these things are necessary as we go forward. We just have a couple of minutes, and I'm going to give you just 30 seconds to have a response. What it is that Norway, Sweden, New Zealand, what is it that they have, because they don't have a lot of legislation, that countries like us, like Pakistan, like some of the more corrupt countries, I'm sorry to say that, what it is that they have that more corrupt countries do not have? Quickly.
Yeah, they have very strong public institutions, very strong auditors general departments. They teach anti-corruption to children from the primary school level onwards. So you develop national systems of integrity from the babe in arms, go up to the adult. So when they reach the political ladder, they will do what is right.
Okay, so a culture is built based on information, education, etc., and therefore an ethos developed that is against corruption, and corruption therefore becomes a no-no. And whatever legislation is really for the aberrant, because the culture is hostile to corruption. Is that correct?
That is absolutely correct.
I want to thank you very much for talking with us this morning, Mr. Ramkissoon. It has been a very enlightening discussion. I'm sure that there will be more opportunities for discussion on this as the regulations come under parliamentary scrutiny. And I thank you for talking with us this morning, and I hope, I'm sure listeners learned a lot this morning, viewers learned a lot this morning. Thank you very much. This is Brighter Morning with Bhoe. We thank you for watching. My name is Bhoe Tiwari, and we are on to the news now at 7 with Chanel Alsuran.